Thank you so much for watching Law School Made Easy at Law School Made Easy 256. Today we want to straight go to constitutional law, and we want to look at the lawmaking process, but this time we are going to look at the lawmaking process for the bylaws, ordinances, bylaws. That's where we want to put our emphasis today. And the first thing we want to discuss is the mandate of making laws in this country. We know that it is the parliament under Article 79(1) that has the mandate to make laws, and no any other body is supposed to make any law as per Article 79(1). But again, in Article 79(2), Parliament can delegate, pass on the powers of making law to any other body as it may find necessary. So Parliament will give a body. For example, we have KCCA mandated to make other laws, NEMA, we have other bodies like URA. So that mandate comes from Parliament under Article 79. And remember the rule governing the publication of the making of laws is that when Parliament confers a benefit, confers powers on you to make such laws, then you cannot delegate further. In the principle of delegatus non post delegare, a delegate cannot delegate further. It is now your work to do that job which Parliament has given you. So our topic of concern today are the bylaws. We want to discuss how are the laws made. How are the bylaws made? First and foremost, let us appreciate Article 180 that gives the local government mandate to do both executive and legislative role. That 180, Article 180 of the Constitution has given mandate to the local councils to have executive and legislative powers in terms of making the law. And what they make is what we call a bylaw. The question is, what is a bylaw? A bylaw, these are laws made for a particular jurisdiction. They cannot work in the other jurisdiction. For example, laws which are made for Kampala capital city, they cannot work in Moende, they cannot work in Jinja, they cannot work in Mukono. Why? They are made for a particular jurisdiction, and that is where they operate. You cannot say that a law against vendors in Kampala was made and it's got to apply to people who are in Wakiso or to people who are in Jinja. It cannot apply. The people in Jinja shall make their own bylaw, as the people in Kampala are also making their own bylaws. So that is what we mean by a bylaw. So now, let us now go to the procedure and processes that you must follow while making the bylaw. There are 10 steps. There are 10 steps that we need to go through, and we appreciate. Yes, the first step is setting of the law committee. That you cannot begin by making the bylaw minus the law committee, the committee in charge of making that bylaw. That there must be a law committee at somewhere at the county, somewhere at the division. There must be a law committee. You first institute a law committee. It is there to scrutinize, to look at what wants to become the law, okay, and then they move with it. So that is the first. You have to first set the law committee. Now, after you have set the law committee, now you have the body which is going to handle the process of making the bylaw. Now, we now go to the second stage, which is problem identification. Now that we have the law committee in place, we now identify the problem. What is the problem? Why do we need? Assuming our problem is the street vendors in Kampala. So we say we have many street vendors in Kampala. What could be the challenges with them being on street? What is coming up? You now identify the problem that you intend the law that you're going to bring to work on, the bylaw to work on, to solve that very challenge. So we are saying you form the law committee, and after you now have identified the problem. Now, when you identify the problem being the street vendors in Kampala, this is now your problem. You now look at in the third element, we have the existing laws. You look at the existing laws and the areas which need to be improved. What do we mean there? That the vendors in Kampala, it is possible that the street vendors in Kampala, there might be a law working on them. Now, you look at that existing laws. What are the gaps in the existing laws? What do we need to improve, assuming the law is there? But if you have identified the problem and now you find that that problem has no law governing it, there is no bylaw covering it or governing it, there is no bylaw that is governing it, then that tentatively means that now you are going to formulate a new law. But ideally, we first look at the existing laws. What could be the gap? What do we need to improve in this law, in this bylaw? Are there challenges? Okay, when you identify them, now you say we have our law committee, we have identified the problem, we have looked at the existing laws, and we have seen there are gaps to improve. Now you begin in the fourth stage, you begin what we call the consultation. Procedure number 4 is the consultation. Now you begin to engage stakeholders. This includes the people the bylaw is targeting, the street vendors. You begin to do consultations. That you see, guys, you guys are on street, but you see when you're here, there is overcrowding, there are a lot of crimes coming up because you're so many on streets. When tourists come, you begin to engage. You engage with the street vendors because there are the problems you identified. You now consult them. What do they think? You bring other stakeholders. For us, the road users, you begin to consult with all stakeholders, and then here now you are getting the gist of the bylaw, why it is important. You're picking ideas of different people. Now, after consultation, now our fifth stage is you draft the bill. You now draft the bill. That after you have done your consultation, you now know that here there is a problem, we need to improve on this problem. Now what you do, you draft the bill. When you draft the bill, you now include everything you found out in the consultation. You include all these things in the bill, you draft it. Now, when you draft the bill, you have now included everything you consulted about, you identified the problem, you saw the law, you now you draft a clear bill. Now, after drafting the bill, the sixth procedure now you go to, you now propose and introduce this bill into the council. Now you bring the bill to the speaker in the council. You propose and you introduce this bill in the council. Now, the moment you propose and introduce the bill in the council, it now means that you have now handed over the process to begin of now fully formulating this bylaw, of making the bill to become a bylaw. Now, when you propose and introduce, at that point now, it has moved out of your hands. You who brought the bill, it is now to the speaker and now the council to begin working. Now, the first thing the speaker does is publication and dissemination. Under the seventh procedure is publication and dissemination. What do we mean here? Now, at this point of publication and dissemination, the speaker will make copies of this law and ensure that all members of council have access to it, and send to all members of council within about 14 days. Now, when the bill is now put to all members of council, they have it. Now that bill is ready to be debated about, because the people who are supposed to debate about it have now gotten access to the bill. They now have it. They have gone through it. They actually required to give their submission in writing from every section of the bill that I think this bill is not accepted ABCD. Now, when the bill is now brought closer to the members of the council who are supposed to be to debate it, we now go to the eighth procedure, which is debating of the bill. Now, the members now with the speaker on floor shall now debate about every section of that bill that you have brought. When they debate about it, they will debate, do amendments, improve on the bill until when the bill now is ready. The bill now is ready, that they will debate and pass the bill. In this phase of debating, we have improving the bill, removing some sections, amending, and then after they will debate and the speaker will now be ready with the bill when the members of the council have now passed the bill. Now, when the members of the council pass the bill, that bill has not yet become a bylaw. Has not yet become a bylaw. Remember, Article 2 of the Constitution provides that any law or custom that is inconsistent with the provisions of the Constitution, that law and custom to the level of its inconsistent shall be void. Now, the ninth step is what we call the certification of the bill. Now, the bill, after it has been passed, the speaker will now send the bill to the district and also or to the minister for certification and approval. Why? They want to check this bill which has been made, is it violating human rights? Is it in line with the Constitution? Now, when all that has been proved, that this bill, they now attach a certificate of approval that this bill is a good bill, it does not violate any laws of this country, it is a bill that can be followed in that area, then it is okay, they will approve the bill. Now, the moment the bill is approved, it is now forwarded to the Attorney General, who is supposed to assent to that bill, and then it will now officially become a bylaw. The Attorney General will assent the bill, and it will officially become a bylaw. Now, after it had become a bylaw, in the last step, the 10th step, publication to the public. The bill now should be put, one, in the Gazette, should be announced to the people, and the announcement is clear. You inform the people who the bill is targeting, why the bill has come, and when is it going to start, the commencement date, that this bill has been passed, it has been assented to, and it will start effective this date, such that the public organize and prepare for that new bylaw which has been made. So the last step is the publication. So I want us to go through these other steps once again. We said the first step is setting up a law committee. The second step is identifying the problem, looking at the existing laws and the gap to use, then consultation, and then drafting of the bill, proposing and introducing of the bill, and then we have the publication and dissemination to the members of council, then we have debating of the bill, and then we have the certification of the bill where we have the approval and assent to the bill by the Attorney General, and then the publication of the bill to the public. However, as we conclude on this one, this process has not been successful in most of the regions, simply because of one, the people who know the legal system at the level, the criteria, for example, of someone to become a councillor, Muluka, you find that they don't know how to hold the law. And also the financial muscles have failed these divisions from conducting this process very well. It is done only in a few areas. Other than that, we thank you so much for watching Law School Made Easy at Law School Made Easy 256. Thank you so much. Subscribe, share, like our videos. Thank you.